For the record, I believe the victim is appearing virtually.
Lori Daybell.
All right. We have a number of things to discuss and get through here today. First of all is the motion for new trial the defendant filed. I received the response. I think the reply is due today. Is that being filed?
Yes, Your Honor, I have it right here. And
Is it ready to be filed?
yes,
Okay, we'll file that. You have a copy for the state?
I do.
Okay. The response, I'll take a look, or the reply, I should say, I'll take a look at that. The next thing I wanted to discuss was the state had filed a notice of its intent to use defendant's other acts to establish conspiracy, premeditation, and/or establish motive pursuant to Rule 404B. In your pretrial statement, you indicated you wish to strike or withdraw that?
Correct, Your Honor.
Okay, so that's withdrawn. Next we have state's request to preclude the media from showing the face of a testifying witness, one of the witnesses. I'm assuming you don't really have a dog in that fight, Ms. Daybell? Or do you have a response?
I don't have a dog in the fight, but I haven't had a chance to read over. I just got a bunch of this stuff, so I'm not really sure what they're asking for.
Well, one of the witnesses also works in an undercover capacity, and showing that witness's face could compromise other investigations or things that that witness is doing. So it's a request to not broadcast his face through the media out into the public.
And is this witness FBI or something to that effect?
It's Nicholas Balance. I think he is an FBI agent.
Correct, he is an FBI agent.
And he's a relevant witness because of why?
According to the state's notice, he created a PowerPoint regarding some of the Wi-Fi or cellular data
Cellular
location.
and Wi-Fi use, yes.
Yeah.
I have no real objection to him being obscured. I don't know how they'll do it, but
All right, so I'll direct the media during trial when witness Nicholas Balance is called to testify. They can't broadcast his face out. They can focus the lower part of the witness stand or something like that, but his likeness or image or face should not be broadcast out to the public. So I'm essentially granting the state's request in that regard. Next, we have state's amended request for Rule 609 hearing and the defendant's response. When I read the amended request, you're simply adding the most recent conviction, correct?
Correct, yeah.
You didn't really respond to that in your reply. You kind of just talked about the previous reply that you had made about, did you notice that she had asked to basically add your most recent conviction?
I saw that, but I didn't know what the law was since I wasn't sentenced for that yet, so I wasn't quite sure where to go on that, so I left it off.
Okay, with the 609, I think similar to the last trial, I'll put that off, and depending on if you testify or not, it only really becomes relevant if you decide to testify. So we'll table that for the time being. Next, I have the state's motion limiting to preclude inadmissible evidence relating to Tammy Latchik, who is a evidence scene technician type person from the, I think it's city of Chandler.
Gilbert.
Gilbert. Did you have a chance to review that?
I just got it, and I am in the middle of responding to that. But I do have a request in that regard.
Which is?
From the state. Since it was, just given to us, and I'm sure that the state had that information clearly before now, we need additional information, and due to that late disclosure, I was going to ask the state if they could disclose to us the employment records of Tammy and the emails regarding this incident and any recordings or body cam videos so that we don't have to have my investigator try to do an investigation so quickly. If they have that information, if it could be turned over to the defense so that we don't have to try to gather that information so quickly.
Well, I don't think you're necessarily entitled to all those things if it's deemed that incident is irrelevant to her testimony. So I think the threshold issue is if you want to file a response where you think that is relevant, something that you can get into, an incident that happened 4 years later, I guess when can you file your response?
Without any further information, I don't know when is that response necessarily due, Your Honor.
It was filed May 3rd, so technically it's already past due. So can you file it by next, you have a copy of it now?
I just got a copy, correct.
Right. How about next Wednesday, the 21st?
Yes, I can do that.
All right, so we'll set
And I have
that
a
aside.
question on that as well. Can I make an objection on the sealing? Can I ask under what law or rule or statute that this motion was sealed under?
They've requested to file it under seal because of the nature of the motion and the contents of what that incident is, not needing to necessarily be in the public eye. So if you want to include in your motion an objection to it being filed under seal, you can do that as well.
Okay.
So you'll file that no later than May 21st. I don't need a reply on that. I'll deal with that, I guess, probably our first day of trial or so.
So you're not going to set a 609 hearing?
This is not a...
Oh, not the 609, but a hearing for Tammy Lachik?
I can listen to oral argument when you filed your reply, but I don't believe I needed any sort of hearing on it. So I'll deal with that May 29th or 30th, I suppose. All right, then we have the defendant's motion for no restraints in trial dated May 6th. I don't know, in your motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here, and I copied it verbatim.
Yeah, you
Okay,
said, what it said was my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation. I've received, the defendant's motion, I've received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph V. Hill for the Sheriff's Office, if you have any questions.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket. We did that. We rectified the situation. There's been no indication whatsoever that the jury noticed the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right. There was no request for that. All right. So next we have defendant's motion to consult with advisory council and team during trial dated May 6th. I don't know, I guess what exactly are you requesting? Are you requesting that during the lunch recesses you be housed somewhere where you can meet with your team?
Correct.
Okay.
And I know that it's a DO situation, and I know that our DO has his other obligations to do, so I didn't know if another officer could if something could be arranged so that I would have time with my team during those breaks and during lunchtime.
We did accommodate that during breaks and recesses during the trial to the extent that it doesn't delay the jury getting into the courtroom and resuming the trial when we need to, like when we take the 15-minute afternoon recess. That will continue. You'll have an opportunity to meet with them briefly. Over the lunch hour, I think is the real question. I did receive a response this morning from the sheriff's office, which indicates they don't really have an objection to that. Is that correct?
That's correct, Your Honor. There is an area on the 4th floor in the South Court Tower where she can be taken to meet with her advisory council, and they'll work that out.
All right. I don't have a problem with that. So if you need to meet with them when we break for lunch, just indicate to the DO that's what you need to do. There may be a day where you don't need to meet with them, but I'll essentially grant. Ms. Kay, I don't assume you have an issue with them.
I have no position on it.
So I'll grant the defendant's motion on that she can meet during the lunch hour. Again, the only restriction on that is that we're not going to delay bringing in the jury at 1:30. We'll expect everyone back in the courtroom to start on time. All right, let's talk about the trial schedule and the screening. I received in the state's pretrial statement. Have you seen that?
I just did, yes.
Your Honor, may I be
Yes,
excused?
go ahead. Thank you. The state's pretrial statement indicate there was some witness scheduling issues. If we get the jury sat on the 30th and impaneled on the 30th, the last Friday in May, and we have our opening statements and begin testimony and evidence Monday, June 2nd, you indicated that the state indicated you would run out of witnesses either Wednesday or sometime Thursday.
Correct. That are available that week, yes.
Right, and then so we'll definitely go dark on Friday the 6th. I had initially indicated we would be in trial on that day, but if we can't have any witnesses here, we'll be dark on that day, and we'll indicate that for screening purposes for the jurors. I think we'll still indicate that we'll be in trial on the 5th, and we'll have to play that by ear. Maybe we will be dark, maybe we won't. But as far as when you resume on the 9th, you said you thought you would have 3 witnesses left at that point?
Correct.
Do you have an anticipation? Are those witnesses that would each take a whole day, or?
I think it's possible I could finish that day.
So ultimately what I'm getting at is trying to drill down the schedule and screening for the jury. Do we not need to screen them for the week of the 23rd?
Obviously, I just received the defendant's 15.2 that lists 2 different expert witnesses. I did request that they actually comply with Rule 15.2 and give me any information about any of these experts. They've also listed other witnesses. So because of that, I would still screen them for the other week.
Well, maybe we should address that. Is there still no report from Lonnie Dworkin that the state's received?
I have received nothing.
Right. Do you have some sort of expert report you were disclosing?
We will, Your Honor, yes.
When?
Well, when is that going to be? Because it's way past due.
So the state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery in the middle of trial. So we did have that. He's working on a few things for us as well now, and I will get with him as soon as possible and get that report to you as soon as possible.
All right, well, it's depending on what's in that report, it is likely to be precluded at this point, but I'll keep an open mind on that, and I guess we'll wait and see. Let's talk about, for the purposes of scheduling.
Your Honor, and just, there's one other person that I Googled.
I'm going to ask her about the other witnesses. I received your supplemental witness list, I think yesterday. You have, in addition to Mr. Dworkin, you have Weaver, Barkman, again, Detective Moffitt, Jeffrey White, Melanie Gibb, and Zulema Pastanas.
Zulema Pastanas.
Okay.
Mm-hmm.
Was Detective Moffett also involved in this case?
He was involved with the case agent of this case while he was the case agent of the other case, correct?
Okay. So he may or may not have, he may have relevant information. Again, I guess that's a wait and see. What about, who's Weaver Barkman?
So he's a ballistics expert.
Is that an expert? So that's an expert. Do you have an expert report that's been disclosed?
Not yet, Your Honor. We're working on it.
Your Honor, since I have not noticed a ballistics expert, that's a big problem, because if I get something, then I would have to do that. So the defendant's, again, extremely late violation of all rules of criminal procedure is a problem.
It is a problem. Who's Jeffrey White?
My investigator.
Oh, okay. And do you have an idea of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two things do not exist. So I'm not sure what they're going to be putting up as far as ballistics in their case in chief, so I was trying to have someone who could be able to look at whatever reports they're trying to put up and rebut anything that they're saying.
Is Mr. White an expert in that area?
Mr. Weaver?
No, I said Jeffrey White.
He's my investigator.
Right, that's who I was asking, who has relevant information. What's Mr. White's relevant information for, why might he be called as into trial?
Because he's interviewing the witnesses as well, the defense witnesses.
So is it some sort of extrinsic impeachment if they,
Correct.
what about Melanie Gibb?
So Melanie Gibb and Zelina Pastinas were both initially noticed in the state's 15.1. They have not noticed them again. I don't know if they can still call them if they're on their list, but
Have you,
they have relevant information to this case.
have they been presented for an interview by the state?
They've both been interviewed multiple times by the state.
I mean, not by police officers, I mean by either a prosecutor or someone in her office for, in preparation for trial.
In this case,
Yeah, in either case,
not that I'm aware of.
have they been subpoenaed?
The subpoenas are out.
What relevant information would they have?
They have relevant information to Brandon Boudreaux
Okay.
and around that time.
What is the nature of that relevant information?
It will come apparent if they have to get up and testify, Your Honor. I will only call them if I need
Well, they're going to
them.
be precluded if you can't give me some minimal, what relevant information they have. Just saying that they're relevant doesn't make them relevant, okay?
Yes, and is this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state? It is?
Yeah, it's
That's
just
how
like-
it works?
like
That's
the-
the rules of law?
Stop interrupting me. Yes, that is the rule of law. That's just what the state does. They tell you what relevant information each witness has. So my answer is yes. So if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox. So
Okay, so does someone, that was a server for them at a restaurant. It doesn't make them have relevant information as to this case. Anyone who came into contact with Mr. Boudreaux or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
the state had them on their witness list and they're saying they're not relevant?
Apparently not. Are you calling them?
No, they're not on my,
Police interview however many people they interview because they're working on the case. They don't know who has relevant information, who doesn't have relevant information. All the people that they interview don't end up being relevant. So because they're listed in a police report somewhere, doesn't necessarily make them relevant.
Okay, their relevance lies in if I have to rebut something that the state puts on in their case in chief. They're just called in case they need them. They're subpoenaed in case I need them.
All right. It sounds like they don't have relevant information. However, I'll include these names on the potential witness list for screening the jurors if the jurors have any knowledge of any of these witnesses out of an abundance of caution. That's really the purposes for today, is the questionnaire that goes out to the jurors. So I will include these witnesses. Again, Mr. Dworkin, Mr. Barkman, if they're expert witnesses that haven't provided any sort of report or expert witness testimony, they're likely to be precluded as witnesses. But I'll include them on the witness list. I think what I'm hearing is you said you might finish on the 9th or the 10th? I'm going to indicate on the questionnaire to the jurors, potential jurors, that the trial is likely to end by June 13th, Friday, June 13th. However, I'll include that Monday, the 23rd, and kind of say, if needed or if required, might go to June 23rd out of an abundance of caution. So I'll finalize that questionnaire. It's pretty much done, and it's pretty much the same as the last one except for the names of the witnesses, the specific allegations, and then I removed the question about viewing medical examiner autopsy type photos because that's not needed in this case. But I'll send you guys out a copy. Actually, I could probably finish it in the next couple minutes and print out a copy so you have it before you leave here today. That questionnaire, I need to get with the jury office. I think we were talking about sending it out the 22nd and cutting it off the 28th or 27th. And then we'll meet again on the 29th in this courtroom to go over the responses. That'll be at 1 p.m. on the 29th.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
What's the name of the case?
Yeah, but you don't put that on anyone else's questionnaire, or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done. And
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name? Do you have a response to that?
I'm just saying, you gave them the name, and they're just going to Google it.
They're instructed not to Google it, all right? And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that. If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor.
So So the schedule will be, we'll meet 1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have walk-in jurors that morning that will fill out the questionnaire. And then the people that survive are screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower. Again, I expect to seat that jury at some point that afternoon. And then we'll plan on going Monday through Thursday, June 2nd to June 5th. Then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that, all right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours, okay?
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have a legal basis, and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions, you denied every one of my second team's motions, and now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied, every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of a conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else? All right, I was handed a motion to suppress all evidence pertaining to Jeep Wrangler.
I have not received that.
Did you probably got a copy of it today or not?
No.
Oh, do we need to make copies?
I just wasn't sure if you wanted to see them beforehand.
All right, go ahead and make copies for the state. I also have a motion to dismiss for non-preservation of crucial evidence. So make a copy. I guess the state can file their response to those. All right, anything else for today from the state's perspective,
No, Your Honor.
from the defense?
No, Your Honor.
All right, we'll see everyone on the 29th at 1 p.m. Again, that's in this courtroom.
Yeah, thank you.
Thank you.
That was